Jaime Zarate. Leon Baker. Carlos Gatlin. Gregory Horton. Jesse Epperson. Lisa Pease. Zanitra Porter. Here. William Petty. Josue Rodriguez. John Dunlap. China Bradley. I saw Miss Bradley in the hallway with Mrs. White. And Renman Yu. All right, is there anyone whose name I've not called? Say, who do we expect to be considered this morning? You have some pleas this morning.
It's the Epperson. Not quite ready. China Bradley.
I think that was it.
Let's see, Mr. Abraham, you asked Mr. White to step in, so we need to make an announcement on Raymond Hughes, so I can get mine from her. All right. Oh, never mind. Last time I saw you were out there, so I think you're still out. All right. Let's go ahead and get to Mr. Yu, I'm gonna have to sit you out after Mr. Abraham, without you. Sorry, hey, he was going to get here.
Come on, Your Honor. Good morning, Your Honor. Can you hear me?
Shaw, can you hear me? Shaw, can you hear me? Good morning, Ms. Shaw. Can you hear me? Let's see, I'm not hearing you at all. Check. Okay, can you hear me? Can you hear me, Shaw? Okay, and I can't hear you. Yes, and I can only hear you. I'm in the. Okay, excellent. All right, good morning, Ms. Shaw. Thank you for joining us. If you'll go ahead and state your name and your license number for the record. Shaw, if you'll raise your right hand, I'll place you under oath. Will you solemnly swear or affirm that you will make a true translation of the statements of the court, the questions of counsel, testimony to be given by the witness in the matter now on trial to the best of your skill and judgments? All right, and if you can go ahead and switch over and see if you can establish communication with Mr. Yu. Right there. And yes, his microphone has to be muted in Zoom, otherwise it creates a feedback loop. Can you hear him at all through his inline microphone on headset? Can you hear Mr. Yu at all though through his inline microphone? You can. It was just a moment. Let's fix it. You do this quite often, so I want you to unplug his headset. Shaw over here. I went flip over to the Chinese channel. So here. Have him say something.
能听见，你说话我能听见。
Okay, all right. And you just have to make sure that you switch between channels if he's talking. All right. The court calls call number CR 23-00070, State versus Redmond U. Court finds that this was set on the docket for, I believe, docket or actually evidentiary.
Yes, sir. We had set it for an evidentiary hearing. State filed a motion for continuance on that. Their officer's unavailable. Obviously, we need the officer here. So as we're reset it. I wouldn't know to the court. I mean, my client didn't apply. So he's got a trip.
If we set the case for August 24th, they go consult with the officer and make sure the officer's gonna be available before we reset.
Yes, Your Honor.
All right, Mr. Wise, give me, comments on August 24th, that's the next evidentiary hearing.
I will be here.
All right, and the court has already granted, state court grants the state's motion for continuance, court will set this for evidentiary hearing on August 24th at 9 AM. And I believe the court has already scheduled Ms. Shaw again for that same day, so she will be available for us. Ms. Shaw, if you will ask Mr. Review if he has any questions, Mr. White or before he's released.
暂时没有。
All right, thank you, Mr. Yu. We'll see you back on August 24th.
Your Honor, I have another case of the document. I'm gonna step out. Speaking of Mr. Keith's families.
Yes, sir. Yeah, thank you, Sean. Appreciate you being here. And I guess we'll see you back on August 24th. Do we have any other attorneys that are ready? So no. Okay. This carries an understanding that your counsel is wanting to be in chambers, is that correct?
That's correct, Judge.
All right, court's going to stand in recess, resume shortly. Are you ready with Mr. Epperson?
Yes, Your Honor. Just signing the last page here.
All right, court calls cause number CR 22-96 and 97, State versus Jesse Henry. Mr. Epperson, if you'll raise your right hand, I'll place you on your oath. Sir, do you swear that the testimony you give in the court today is the truth, the whole truth, nothing but the truth, so help you God? Yes, sir.
Your Honor.
Yes, please. Elliot. Miss Curry approaches, which I think she's outside. Please. All right, Mr. Epperson, your name is Jesse Henry Epperson the fourth, is that correct?
Yes, sir.
Mr. Epperson, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Zach Elliott. Will you please, Mr. Elliott, the work is done for you?
Yes, sir.
Feel like you've had enough time to talk about your case, and you've had all of your legal questions answered.
Yes, sir.
Is there anything about the paperwork that you've read over and signed today that you do not understand?
No, sir.
Mr. Elliott, do you believe Mr. Epperson to be competent?
Yes, sir.
Have you explained to him, Ms. Rice, the contained of this plea agreement, specifically the advantages and disadvantages of the deferred adjudication?
Yes, Your Honor.
Mr. Epperson, you are charged by indictment with a second-degree felony offense of arson. Second-degree felony, there is a punishment of not less than 2 years or more than 20 years in prison, and a fine not to exceed $10,000 if you were convicted and sentenced. Do you understand that if I follow the plea agreement in this case, and you're placed on community supervision, if at any point during that period you violate any of the terms and conditions of your community supervision, the state may file a motion to adjudicate your guilt, convict you, bring you back before the court. And if the state's evidence proves words beyond a preponderance of evidence that you have violated any of the terms and conditions of your community supervision, the court could do a multitude of things, including adjudicating you, convicting you of this offense, revoking your community supervision, and assessing punishment from the minimum 2 all the way up to the maximum 20 years in prison. You do understand that?
Yes, sir.
Understanding all of those things, you still wish to go forward.
Yes, sir.
Mr. Epperson, how do you plead to the second-degree felony offense of arson?
Good.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
The court accepts the defendant's plea of guilt. Mr. Elliott, any objection to the stipulation of evidence? Stipulation of evidence is admitted in evidence, the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
No, Your Honor.
Any further from the defense? All right, the court has reviewed the stipulation of evidence. Court finds sufficient evidence to convict Mr. Epperson of this offense. Court finds that the recommendation from the state is to defer a finding of guilt, to place Mr. Epperson on 10 years community supervision, assessment of a $5,000 fine, restitution of $1,476. Court costs $290, reimbursement fee of $90. Court also finds that the recommendation is for Mr. Epperson to be placed on a mental health caseload, and as a specific addition of community supervision, have no contact with the victim of this case or her family. Based on the recommendation of the state, the court will follow that recommendation. Those sentence as previously stated. All right, Mr. Epperson. Court has imposed sentence pursuant to the state's recommendation. Hereby ordered custody of the Bennington County Community Supervision Corrections Department. Court finds also that you ordered to serve 20 days confinement in the county jail as a condition of your community supervision. Court finds that you have credit for time served on that condition from January 26th, 2022 to February 5th, 2022, also April 25th, 2022 to May 3rd, 2022. Mr. Everson, you understand that if you violate conditions, you come back to the court. The issue before the court will be not whether you committed the crime of arson, you already pled guilty to that. The court's already considered that and has further finding. The only issue before the court on a motion to adjudicate or revoke is whether or not you violated supervision. Understand that a single violation can have your community supervision revoked, but any sentence assessed will be for the crime of arson. So if you get on community supervision and you smoke weed or you drink a beer, you come back to this court, the court adjudicates you or revokes you, or will not sentence you for smoking weed and drinking a beer, or will sentence you for arson. Yes, sir. Understand that? Yes, sir. All right. All right, Mr. Everson, I'm gonna have you, Mr. Schmidt, table right there. We're gonna make a constitution. Mr. Elliott, you're going to have a Schmidt, go ahead and see whether Mr. Schmidt was, and Mr. Everson, you can have a seat right there. Deputy Martinez is going to come take your fingerprint. And if the victim wants to come and allocute at this time. So the court finds that this is allocution and not the only. Yourself. That chair moves around, so make yourself comfortable. Oh, thank you. Go ahead now.
Go ahead.
Yes.
I've waited a long time for this. I appreciate the court giving me the time to say what I have to say to his face. On April 25th, 2022, when they found you in Fort Worth and arrested you, I thought, wow, what a birthday present for the both of us. I just knew after you fled and after all of the evidence, they were going to lock you up until trial and then lock you up afterwards. Tomorrow, it will be exactly 1 year and 6 months since you committed these violent acts. Almost 7 years ago, I got a second chance at life. You have taken up a precious 1.5 years worth of time and emotions and stress and blood pressure in my life that was almost cut very short. I may not ever be able to forgive you for that. I chose not to show up at the hearing this past April when I thought this was going to be over. I knew you were going to be free to walk out of here, and I was terrified that you or one of yours would come after me or my family because you were mad that you got caught this time. I'm glad I got another chance, because if I had chosen not to come, I thought I might feel like a coward like yourself. I am nothing like you. I'm a good person who stands up for what is right and what is wrong. I have a purpose. Your only purpose of being alive is to cause harm. I don't know you, but on December 24th, 2021, a family member brought you into my parents' home, and we welcomed you into our family Christmas celebration. We offered you food, drinks, entertainment, and kindness. 1 month and 2 days later, you disrespected my family and myself in a way that is terribly violent and traumatizing. Besides murder, this is the worst thing that you could do to another human being. You burned my house down and destroyed everything that I own. You set fire to everything that I've worked for my entire life, as well as things that belong to my parents and their grandparents. You destroyed the place where I lived, my shelter and my home. You took away our belongings, but more importantly, You took away our ability to ever believe that we are ever completely safe in our own homes. When I have told this unbelievable story, here are words that my friends and family, even complete strangers, have said about you. Soulless, evil, subhuman, criminal. These are words that will always be used when anyone speaks of you. First of all, I'm not even doing this for you. I can't even look at you. I don't expect you to comprehend in any way what you have done or what you have really taken from us. You have no clue of what we have been through, what we have had to do, the trauma, the money, the time that we've had to spend due to what you did. Whatever your plea is, I've never received an acceptance of guilt from you. I've never received a letter of regret from you. I've never heard, I'm sorry. Are you going to try to make this up to me now? Are you going to undo what you did? Are you going to bring back my precious home and my family's heirlooms? It's impossible. I sure don't expect someone like you to feel any regret or any human emotion in response to anything I have to say anyway. They say you have a hero complex. You are no hero. You are the exact opposite. You cause harm to first responders. You lie. You tell real firemen, that there are people in a burning house when they're empty. You do understand that you should be on trial for attempted murder for sending innocent men into a burning building to look for victims that you've made up. There's one where you should be convicted. There's definitely an eyewitness to that. I'm so glad that they survived the massive fire that you started. They risked their lives trying to save others. They are the heroes. My dad is a 38-year veteran of Dallas Fire and Rescue. He's a hero. You're not a fireman. You're not even a man. You're not mentally ill either. You're just evil. You knew exactly what you were doing. You were smart enough to spend hours preparing to commit this heinous act. When you spent hours at my house 2 days prior on Monday, you had enough mental ability to know how to cut my internet wires and shut off my security cameras without them getting any videos of you on my property. Still baffled by that. You spent time sanely thinking about how you could destroy someone else's property successfully. How could someone like you be smart enough to bypass my security cameras? Is it because you had plenty of time to study my house while you were at your buddy's house next door all those times? You know, that other house next door to mine that mysteriously burned down 6 months prior to mine? There's eyewitnesses to that too. Just saying. My mother was asleep on my couch the night of that fire that mysteriously was set 100 yards maybe from my house. Lucky for everyone that it didn't drift over a few yards to my house on that night. What if these fires got out of hand? What if mine had got out of hand and the firemen were too busy at the other fire that you sat that night? What if it killed Mr. and Mrs. Hubbard, my neighbors, my other neighbors? You're no fireman. You wouldn't have a clue how to save them if something got out of hand. Being a Christian woman, I know that I'm supposed to forgive you, but I don't have to right now. And I don't ever have to fully. Forgiving someone who terrorizes you, forgiving someone who is capable of doing it again, is just too hard for me to do right now. Raised in a loving home with parents who taught me right from wrong. I was raised in a home where there was always friends, family, joy, and music. You must have been raised by wolves. Your actions are worse than those of a wild animal. Because that is what you are. No one is safe until you're behind bars. No one is safe until you're caged like the animal you are. You are the boogeyman. You are the demon in kids' nightmares. You're the big bad wolf who comes in the middle of the night while you're sleeping and burns your house down. As my husband says, I am strong, and I'm way more strong than you ever will be. I have lived through worse things than a monster burning my house down. I have survived a life-threatening disease and everything that comes along with it. A heart transplant, a liver transplant, my only brothers, my best friend's untimely death, and I will make it through this one just fine. I have a great family, a husband who loves me, great friends who stand by me. I have a career. I have people who respect me. I have dogs that I'm very thankful that weren't trapped in my house when you decided you was going to set it on fire. I have a life, and I have a great life, and you will never take any of this away from me. After this, I am done. I will no longer have to think about you and what you have done to us. You're the one who has to deal with what you have done for the rest of your miserable life. If for some unknown reason you were able to rehabilitate yourself and completely change the evilness within you, or if you were to violate probation and be sent back to prison without anyone getting hurt or killed, that would be the only good that could come out of this as far as I can see. As for now, you just disgust me. You are a waste of space. You are a danger to good people on this earth. And just because you're not being put behind bars today does not mean that you are a free man. You are a criminal. You will always be a criminal. I hope you pray to God every day of your miserable life for forgiveness. Thank you for your time.
All right, Mr. Representative, you're about remaining to the custody of the probation departments and carry out the terms and conditions of the sentence. Have you step over here and meet with his officers to give you information on what's next. Great. Sir. Yeah, thank you, Julian. Any other pleas that are ready?
Yes, Your Honor, Miss Bradley.
Sure. No one wanted. Okay. China Bradley, CR 20-1. All right, Ms. Bradley, if you'll raise your right hand, please. Oh. Ms. Bradley, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Make sure you speak up loudly. Ms. Bradley, you appeared before the court on January 30th of 2020. You pled guilty to the state jail felony offense of possession of a controlled substance. At the hearing, the court found that there was enough evidence to substantiate your guilt. The court followed a plea agreement on that day between you and the state. Upon your plea of guilt, the court deferred the finding of guilt, placed you on 2 years of deferred community supervision and assessed a $1,000 fine. It was during your probationary period that the state filed its motion to adjudicate in October of 2020. And in that motion, they alleged 8 counts of various violations. Have you had a sufficient time to review that motion with your attorney, Mr. Nolan White? Are you happy with Mr. White and the work he's done for you?
Yes.
Do you have any questions about any of the paperwork that you've read over and signed here today? I see that there's a plea agreement in this case to resolve your motion to adjudicate. It appears that you should be pleading true to all 8 counts in exchange for the state's recommendation that your guilt be adjudicated. That means that you are convicted of possession of a controlled substance, that your punishment be assessed today at the minimum 6 months confinement in the state jail. With that being suspended, you being placed on 2 years of community supervision, with you being ordered to pay the balance of your previous financial obligations, your fines, court costs, restitution, and reimbursement fees. Is that your understanding of the plea, Ms. Bradley?
Yes.
Mr. White, do you believe Ms. Bradley's competent today?
Your Honor, I believe Ms. Bradley is competent. She understands the proceedings that are being used here today. We have set rights in front of you. I think that she waived the right of voluntary.
Thank you, Mr. White. Ms. Bradley, at this time, I'm going to ask you, how do you plead to counts 1 through 8? Are those counts true or not true?
True.
And are each one of those counts, you're telling me that those are true because the fact of what is alleged is true? You're not just saying that so that you can get a certain plea. Is that right?
Yes.
And Ms. Bradley, has anyone threatened or forced you to make you plead true to any of these counts? The court accepts the defendant's plea true. Mr. White, any objection to the admission of the defendant's waiver of rights plea of true?
Objection.
That is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
Anything further from the defense?
No, sir.
All right, Ms. Bradley, before I go any further, I need you to tell me, why should I put you back on probation? I've already placed you on probation, and I've already given you orders. You violated those. And the state seems to think that you can comply. Tell me, why is it that I should give you another chance rather than just sending you to prison today?
Well, back 2018, I guess, I was a minor. Well, not a minor, but I was 17. I was still a kid. Like now, I think I'm mature. I had a child since then.
Are you through smoking marijuana?
Yeah.
It says here you were smoking weed, you weren't paying, you weren't doing your community service, weren't taking your classes. You're telling me that you're not gonna be smoking weed anymore, you're gonna be responsible, you're gonna pay your supervision fees, you're gonna pay your analysis fees, you're gonna do your community service, you're gonna report. You're gonna do everything that you're supposed to do to comply with all of these orders. Is that right?
Yes, I already completed like some of the classes, and I've been paying like so far. Now that I started back.
Your Honor, Ms. Bradley, you can act, she's still on probation. state my decisions, race, there was some circumstances here. But I told her, she needs to show the judgment of the city. And what the plots and certain. And I explained to her, Your Honor, you know, while everybody would say, maybe this is a fair resolution, but she just did some race, so it's typically not done. And, you know, you can't expect, people to be understanding, you don't follow. And so I told her that I looked forward to take a matter in a neutral manner. But, you know, my experience, more times you come in here, less understanding everybody gets out. And, you know, you got a child, you got a responsibility. And, you know, this is not gonna be the easiest thing, but it's something that she can use, turn around, and use as easy tool for, you know, parenting, whatnot. But she has to take it back, if she doesn't, she's gonna find herself, of course, has no valid. Or, you know, since she's 6 months, or 5. And that's not a way to start off life.
Thank you, Mr. Ryan. Did you hear all that, Ms. Bradley? It's well spoken. He knows what he's talking about. You're telling me if I approve this today, I won't see you again. The next time I see your name, so the probation department hands me a piece of paper and they say, Ms. Bradley's done everything that she's supposed to do. She's off of probation. So the next time I want to see your name. And what happens if you screw up?
Going to jail,
Go to prison. How old is your kid?
15 months.
18 months. And if you screw up, you're gonna lose 6 months of your life. Understand that? Do you know how much a baby changes in 6 months? How many kids do you have? One, so you don't know. Let me tell you, babies change a lot first 2 years of their life. Think about it, they go from not even being able to hold up their head to running around and climbing in coffee tables. You wanna miss all that? Do you wanna come out of prison and your baby not even know who you are? I want you to be thinking about this while you're on probation. I'm gonna give you another shot at this.
Thanks.
All right, the court finds that Ms. Bradley has violated the terms and conditions of her continuous supervision. Court is going to follow the plea agreement today. The court adjudicates her guilt for possession of a controlled substance, under group 1, less than 1 gram. Assesses her punishment at 6 months confinement in the Texas Department of Criminal Justice State Jail Division. Court suspends that sentence, places her on 2 years community supervision, orders her to pay the balance of financial obligations. All right, well, do we have any other pleas that are ready?
I don't believe so, Your Honor.
William Petty. CR 16325. Second, Mr. Petty's motion to vote, status of compliance. That's great.
Progress on.
First one we said, Mr. Petty, so August 24th. To another status of compliance. Madam, are you ready on Mr. Baker?
Yes, sir.
Or Mr. Galvin?
Yes, sir.
Which one do you want to go with first? Are either one of these going to be, is Mr. Baker going to be consensus evidentiary? Okay, what about Mr. Galvin? Just set me off.
Yes, sir. Yeah, I believe it was a status update on the.
Okay. Okay, that's correct. This was the use of passenger and search the vehicle. Okay. All right, I'm gonna resend Mr. Gatlin this to, I've not had a chance to complete that, so I'm gonna resend that to August 24th. Or to, that also that job call. I'll have the review. For Mr. Carlos Gatlin. So Mr. Gatlin, here, Mr. Gatlin, come on. Mr. Baker, you can have a seat right there, that's perfect. Mr. Gatlin. Sorry, I kind of took those out of order. August 24th, 9 AM, the doc call. Before we do that, so you put back and forth in the shots. Or are you back on that day? Our pitch on the day that you're already here, if we could do that, save you a day. You're not already here.
I'm not on.
Okay, let's do that. Let's set up August 22nd then. That'll be for August. I'll have it. Sure. CR 21-288. Yes. Mr. Gallo, once you sign. Thank you. Then I'll call Mr. Baker's case in just a moment. I've got a couple other ones I need to show there. I know you can go ahead and have a seat back there. I'll call you this. Sorry about that, Mr. Baker. Lisa Peace. You called him?
Yeah, he said he was he was gonna do a reset.
Have you talked to him today?
Yeah, he's sick, still sick.
This case, I think we're at an impasse.
I don't know what he had.
I said, I think we are at an impasse, you and I. I have a lawyer.
I do. I figured he'd have someone here.
Go have a seat. See if I can figure out how to deal with your business. Sit down. So need your reporter. All right, Mr. Porter, the board has appointed Jonathan Manning to represent you. All right, so I'm going to reset today's hearing to August 24th to give Mr. Manning time to get your motion. Get familiar with it, talk to me about your case. Okay, I was appointed yesterday. I believe that Ms. Tableman has provided you his contact information. Is that correct? I'm going to have you sign this form. It just says that we're resetting you to August 24th at 9 a.m. Okay. Ms. Porter, I want you to check in with probation before you go, okay? Josue Rodriguez, CR 18503. All right, Mr. Rodriguez, your attorney, Mr. Mercedes, is in trial over in Coffin County. He's not going to be here. The state has filed a motion to withdraw your motion to adjudicate. And they want to extend you, not extend you, place you back on community supervision. Is that correct?
Yes, Your Honor.
Mr. Hartwell, I think in your motion you said that Mr. Rodriguez has re-enrolled in classes and this has been agreed by probation. Is that correct?
Yes, Your Honor.
All right. Who did you speak with in probation?
I spoke with, sorry, Your Honor, let me.
Okay. Mr. Rodriguez, while Mr. Hartwell is looking that up, I have notes here that you still owe close to over $3,500 and you needed to do a lot of your community service. Tell me what your plan is to prevent coming back and forth.
Our pastor was supposed to talk to Patterson, I think, or Walker, to the hours that I've been working at the church. They were supposed to see if I could get credit for those.
Okay.
And
How many hours?
I think it's over 25, I think.
So you still got a lot more to go though, right?
It's supposed to be 360.
So you know, if they don't approve that, you're gonna have to find somewhere else to do it that's already approved.
Yes, sir.
What about your money situation? How are you?
I'm gonna pay 400 of what I owe.
Today, so pay 400 today.
Ms. Burns, Your Honor.
All right, so court, finding that the state's filed a motion to withdraw the state's motion to adjudicate appeal, the court will grant that motion. Place Mr. Rodriguez back on community supervision. Mr. Rodriguez, I order you to go over today and pay your $400 that you said that you're gonna do, meet the probation officer, stay on top of getting your community service taken care of. If you fail to do that, you're getting that back. You understand?
Yes, sir.
All right, you're free to go.
Thank you.
All right, I signed that order in e-file. It's great. Is there any announcement for Mr. Sabate? He was pro se, I believe, on the motion for this.
Yes, Your Honor, I believe we're going to play right now. and then we'll have it.
All right, are we ready to move forward on Mr. Biggs' case?
Yes, Your Honor.
All right, so just so I understand, so we'll go with Mr. Wood. Then we're gonna have test hearings on Mr. Adams' client, Leon Baker.
We're looking at that one now, Judge, to see what's been filed.
And then Mr. White on Mr. Biggs. If you're ready, if you bring your client up. All right, Gregory Dominique Horton, CR 2399. Are there any stipulations or agreements between the parties on the motion today? Your Honor, I would stipulate that there was a warrant. All right. Then you may proceed, Mr. Biggs. I'll forego. The background judge, I filed a pre-trial motion. Person, I think during the basis of that suppression, like again, with testimony, evidence regarding the search warrant that was executed on March 23rd, 2023. And I'll offer a copy of the affidavit to the press. With that, we call Officer Andy. All right, Officer Garza. Yes. How you doing? Got better days. Yes. You raise your right hand. Officer Garza, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So we got. Yes, sir. Take your time. You don't have to talk with that, just speaking up loudly.
Okay,
Go ahead, Mr. Biggs.
Thank you, Your Honor. Officer Garza,
yes, sir.
how are you currently employed?
The Van Police Department.
And how long have you been a police officer?
Been a police officer since 2013.
And you're a certified peace officer
Yes, sir.
and your commission is carried with Van Police Department?
Yes, sir.
Were you working as a police officer on or about January 17th of 2023?
Yes, sir.
You're also working as a police officer on or about 20th day of March of 2023.
Yes, sir.
Can I approach you?
You may.
Officer, I'm gonna hand you what I marked as exhibit number 1. I'll give you just a second to kind of review that and tell me if you recognize that document.
It's the search warrant.
You do recognize it?
Yes, sir.
Is your signature fixed on it anywhere?
Yes, sir, right there.
And when you, now that's the return
Oh.
inventory, which is yeah, there you go.
Yes, sir, right there.
So this is your affidavit for the application of the search warrant to Judge Winters.
Yes, sir.
23rd of March of 2023.
Yes, sir.
And you swore to that document.
Yes, sir.
You swore to the facts in that document, true, correct?
Yes, sir.
Your Honor, I'm going to offer exhibit number 1.
Okay, John.
Sorry, there being no objection to defendants one is admitted. Where's your mission? That's fine, just leave it here for a moment. I think I have a copy.
I'm going to let you, I don't want to.
You can have this officer first.
I'm
You can step over.
also guards if you don't have the top. I'm going to ask questions about it, and I want you to be able to reference it.
Yes, sir.
My first question to you has to do with, what the things, you're aware that when you apply for a search warrant, there are certain legal requirements, correct?
Yes, sir.
You have to have probable cause to believe that a crime is being committed first, is that right?
Yes, sir.
And then secondly, you have to have probable cause to believe that evidence of that crime is located at a particular location that you want to search.
Yes, sir.
And that items you want to seize are evidence of the crime that you allege took place. You understand all those concepts?
Yes, sir.
So in section 2, you list a few things there. One is a body armor. Second is a .40 caliber Glock pistol. And then you also list some things like marijuana and other items used for the manufacture of narcotics. Is that all correct?
Yes, sir.
So that was the things you were looking for that you believed were evidence of a crime. Is that correct?
Yes, sir.
Now, I want to ask you, and I know I'm putting you on the spot, so please understand that I'm not expecting a verbatim answer, but can you generally tell me what your understanding is of the crime and its elements of possession of body armor by a convicted felon? What are those elements of that crime?
Anybody who is considered a convicted felon cannot possess or own metal or any type of body armor.
Close enough. That's correct. So when on January 17th of 2023, you indicate in your affidavit that my client Gregory Horton entered the lobby of the police department, is that correct?
Yes, sir.
And you see Mr. Horton in the courtroom today,
Yes, sir.
seated 2 spots to my right?
Yes, sir.
And while he was there, he was complaining of a terroristic threat, is that correct?
Yes, sir. He was there for other reasons to talk with the chief over another situation. Yes, sir.
And while he was there, he was wearing something that at least you believe was body armor, is that correct?
Yes, sir.
Now, you describe it in your affidavit as full color or colorful Molly loops with hooks. Can you help me understand what that is?
Molly, like the same, this is the Molly vest and the hook and loops is in Velcro.
Molly hooks are the military members and law enforcement use those to attach accessories to their vests.
Yes, sir.
And in fact, would you agree with me that those Molly hooks are actually a part of or option that an officer can order on the carrier itself?
Yes, sir. There are options.
So what you're seeing when you see those Molly loops, you're actually looking at the carrier, right?
Yes, sir.
And then inside that vest are inserts. That's the actual material that's meant to stop bullets.
Yes, sir.
correct? And you observed Mr. Horton wearing such a vest.
Yes, sir.
Did you ever remove the inserts and inspect them?
During the search warrant, yes, we did pull out the plates. They were ceramic.
So on January 17th, when he came into the lobby and he was wearing this vest on, and I believe it's on video, so I'm not asking you a question that I don't know the answer to.
Yes, sir.
He never removed the
Not,
inserts.
not while we were with the PD. No, sir.
So in terms of your viewing of the vest on that particular day, as far as you knew, he was wearing a pretty heavy vest, and at least he claimed it was body armor, correct?
Yes, sir.
No way for you to know for sure without moving those.
Correct.
inserts, correct?
Correct.
All right, I want to move on to the next paragraph in your indictment where you're talking about this Glock firearm. You understand that unlawful possession of a firearm by a felon has the same elements as unlawful possession of body armor by a felon. right?
Yes, sir.
Except there's an exception to the firearm code.
Yes, sir.
What is that? exception?
The state law says that after so many years, they're able to acquire one.
So do me a favor, look in your affidavit there and tell me, where is it in your affidavit that you have articulated that my client is a convicted felon? And I'm gonna answer the question just to make it quick for your officer Garza. There's nowhere in there where you indicate exactly what his conviction is for and when he was convicted. Would you agree with me on that?
Yes, sir.
In hindsight, do you think that would have been a pretty important fact to put into your affidavit?
Yes, sir. It would
The
have.
fact is an element to the crime, is it not?
Yes, sir.
So in order to apply for a search warrant, you have to establish first that a crime has been committed. And one of the elements to that crime is the conviction itself.
Yes, sir.
So nowhere in your affidavit did you list what his conviction was for.
No, sir, I did not.
In fact, I believe there may be some confusion later on.
Yes, sir.
He being arrested about which of his items on his criminal history qualified as the conviction on this case, correct?
Yes, sir.
Which is understandable, you know, police officers, you didn't go to law school, right?
No, sir.
So, but you agree with me at least then that the details of his conviction was not included in this warrant.
Correct.
Let me ask you about Fire Marshal Jeff Hutchins. You know that individual?
Yes, sir.
It says that on 2/8/2023, that he wrote a supplement based on a contact he made back in December of the previous year. Is that correct?
Yeah, yes, 2021.
And it's,
True.
feel free to refer to the affidavit if you need to.
Um,
It's the last paragraph of your affidavit. Do you know which fire department Jeff Hutchins is with by any chance?
I believe it's a Tyler.
Oh, he's in Tyler?
Yes, sir.
But do you see the paragraph there I'm referencing?
Yes, sir.
So I guess my first question is, if Fire Marshal Jeff Hutchins had contact with Mr. Horton on December 31st of 2022, why in February of the following year is he just now writing a supplement? And I guess a better question would be, did you ask him to write a supplement for you?
No, sir.
And you're the case agent for this, right?
Yes, sir.
This is your case?
Yes, sir.
So how is it that Mr. Hutchins or Officer Hutchins came to write you a supplement 2 months later?
Because I asked him for the footage of the lobby, and he says that he remembered back when he was working that night. And he got a call over to Mr. Horton's residence, and he was outside wearing body armor.
That makes sense. Thank you for clarifying that. The footage for the lobby at the police department,
Yes, sir.
Mr. Hutchins, was he like the IT guy or something?
He does a lot of our IT work. Yes, sir.
So he's savvy with all this.
Yeah, and it's off premises, so he has access to it.
And when he indicated to you that he had had contact with Mr. Horton in December, you asked him to write a supplement.
He went on and wrote the supplement for me because he said he remembered back, so he went on and wrote the supplement along with the video footage.
And you also indicate in your report that Officer Hutchins, and don't get me wrong, I don't want you to think that I'm suggesting anything improper. It's perfectly proper for you as an advocate for a search warrant to quote something that another officer says, right? That's the collective knowledge doctrine. You're allowed to rely on other officers, even in your affidavit.
Yes, sir.
But my question is specifically that you indicate that Jeff Hutchins describes the vest as a black Molly bulletproof vest, the same way you described it before when he came into the lobby. Correct?
Yes, sir.
You also indicate that he owned that Mr. Horton indicated that he to Mr. Hutchins or Officer Hutchins indicated he owned a 40 caliber Glock pistol.
Yes, sir.
Is that correct?
Yes, sir.
Now, Officer Hutchins wrote a supplement and then delivered that supplement to you.
Yes, sir.
Were you relying on the supplement when you drafted this affidavit, or were you relying on something that Officer Hutchins told you? Do you remember?
No, sir. what's began on my part was when he came into the lobby and he pulled up his shirt showing the body armor. That's when I started my investigation.
And I'm referencing specifically with the information that you acquired from Officer Jeff Hutchins.
Yes, sir. Okay.
Your affidavit indicates that he also saw
Yes, sir.
this, what he thought was body armor,
Yes, sir.
correct?
Yes, sir.
And he wrote you a supplement to that effect.
Yes, sir.
I approach you. Now, I'm gonna hand you this document, I'm gonna concede to you, likely won't recognize it, but if I were to hand you that and give you a chance to review it, and if I represented to you, that was, Officer Hutchins supplement that you had requested to write, the one that he wrote after y'all's conversation, do you agree with me that that's the supplement?
Yes, sir.
The objection,
No objection, Your Honor.
there being no objection, defendants two is admitted.
I'm gonna let you hold on to exhibit 2 real quick too, before we give it to the judge. Tell me, after reviewing exhibit number 2, is there anything in that supplement that references this vest as being a Molly vest?
It doesn't specify Molly, but it says tactical.
You would agree with me that Molly and tactical are two very different terms with very different meanings, at least in the law enforcement community.
Yes, sir, they can be.
Also, can you look in that supplement and tell me if there's anything in there that references a 40 caliber Glock?
Nothing to references 40 caliber Glock in here.
So when you drafted your affidavit based on the supplement from Officer Hutchins, you inserted your own descriptions in the affidavit based on the information on
You're talking about
Officer Hutchins.
over this,
Molly vest.
he didn't say it was a Molly vest, it's a tactical.
Would you agree with me that it's important for an officer when they're drafting an affidavit to give to a judge for a search warrant, that the information in the affidavit is correct? After all, you swore to that affidavit. did you
Yes,
not?
sir.
And the information in that affidavit is not correct, is it?
According to where he wrote it to where I wrote it, no, it's not correct.
I'm not disputing, be clear, Officer Carson. I'm not trying to pin you down. There's no trick questions here. I was a police officer for 10 years. I appreciate the job. So I'm not trying to trip you up. I recognize that you saw a Molly vest. I'm just saying that based on Officer Hutchins' supplement, you can't necessarily say if what Officer Hutchins saw is the exact same Molly vest that you saw, correct?
Exact same one. May I clarify? After when he brought me this, he brought me his body cam footage as well. So I watched the body cam footage and it was showed him wearing the vest and him saying he had a Glock 40.
So you recognize the same vest?
Yes, sir.
The body camera footage that Officer Hutchins provided you, was that included in your case file?
Yes, sir.
Was that submitted to the district attorney's office?
Yes, sir. Should have been. All my part was turned in, so I assumed it went to the DA's office.
Now, and you say in this body camera footage of Officer Hudgens, Mr. Horton indicates it's 40 caliber Glock.
Yes, yes, sir. In the
And
video.
you're saying that you drafted your affidavit based on what you saw in the body camera footage, not from what Officer Hudgens reported to you. So,
Not word for word from what he said. No, sir.
but you see why that's confusing to me, right?
Yes, sir.
Because your affidavit says that Officer Hudgens is going to give you that information.
Right, correct.
If, you know, I think the better way to have drafted this would have been, I observed the body camera footage and I saw 1, 2, 3.
Yes, sir.
But your affidavit says Fire Marshal Hudgens did a supplement and told me this is what happened. 1, 2, 3.
Yes, sir.
See what I'm saying?
Yes, sir. I see where the confusion was.
Still though, even based on your review of the body camera footage, Officer Hudgens never pulled the inserts out of the vest, did he?
No, sir.
Nobody ever saw what the inserts looked like.
No, sir. He was wearing it at the time when Hudgens was there on scene. So.
Did you ever run Mr. Horton's criminal history?
Yes, sir.
And in terms of the Glock 40 caliber pistol and him possessing it at home, do you have an opinion as to whether or not that's a crime?
We did not charge him with the gun.
Because it's been 5 years.
Yeah, it's been over the time limit, so we did not charge him with the weapon.
Where in this affidavit is there anything about drug activity? I noticed in paragraph 2 of the things seized, the things you're asking to seize evidence pertaining to the crimes. One of the things you list there is marijuana, violations of health and safety code penalty group 1, 1A, 2, 2A, marijuana products, equipment used in distribution or manufacture of narcotics. Where in your affidavit are there any facts that suggest that Mr. Horton might have?
I did not list any facts that goes towards that in the affidavit.
Understand that it's not enough just to list, you know, hey, I think these crimes are committed. You've got to put specific articulable facts mounting a probable cause.
Yes, sir.
You would agree with me that you had no probable cause to search his house for drugs.
Correct. I did not have anything in
this affidavit.
this affidavit. I did not have anything.
Probable cause to believe that he committed a crime in terms of possessing a firearm because it's at his house and he's 5 years past at least what you believed at the time was his felony conviction.
Yes, sir.
You didn't put the felony conviction in the affidavit, so the reviewing magistrate would have no way to be able to conclude that unless you specifically list what that conviction was for and how old it was, correct?
Correct.
And then finally, you never pulled the insert out of any of the vests when he was there on the 17th, and Officer Hudgens never pulled the insert out when he was there in December 31st. So there's truly no way to conclude if that device was meant to stop a projectile from a firearm, correct?
Well, we did not pull any of the panels, so.
Officer Garza, I appreciate your testimony today.
You're welcome.
Thank you, Judge. Officer Garza, just so the folks understand, you've recently had some health issues, is that right?
Yes, ma'am.
And just got out of the hospital.
Yes, ma'am.
That's why you're moving a little slow and gingerly today.
Yes, ma'am. I've just been in the hospital for the last 18 days. So
Got out over the weekend, I think. Is that
3 days ago.
3 days ago? Okay. All right. So, and one other thing to clear up, Jeff Hudgens, he is a fire marshal in Tyler, like you said. Is he also work for the Van Police Department?
Yes, ma'am.
And is he a regular officer or reserve officer?
He's a regular officer. He's actually the fire marshal
Okay.
in the city of Van as well.
Okay. And you said that he does most of your IT work, is that right?
Yes, ma'am.
And that's kept offsite from the police department.
Yes, ma'am.
Officer Garza, one of the things, so Mr. Biggs has kind of established that you allege in the search warrant affidavit that Gregory, paragraph, I'm looking at paragraph 4, Gregory Dominic Horton being a convicted felon. Would you agree with me that that's really the only place that you talk about his prior felony conviction?
Yes, ma'am.
I also noticed, sir, that the date of this search warrant is March 20th of 2023. Was there anything specific that happened that prompted you all to get the search warrant on March 20th when it was January 17th that Mr. Horton came to the police department?
Can you say that again?
Sure. It appears to me, and correct me if I'm wrong, it appears to me on defense exhibit number 1 that this search warrant was signed on March 20th of 2023. Is that correct?
Correct.
And it also appears that the probable cause in the search warrant comes from December 31st, when Officer Hudgens encountered Mr. Horton, and from January 17th, when you and Chief Davis and some other officers encountered Mr. Horton in the lobby there. That's about a 2-month delay, and I'm just wondering what prompted getting the warrant after 2 months.
At the time when he came in, we were working on another case. It was more time restricted.
Okay. Was there any particular reason, any particular event that caused you to apply for this warrant on March 20th?
We were trying to gather information from everybody, since a lot of times he's identified himself not as Gregory Horton, but as Dominique Horton. So there was a confusion in the system.
But no particular action.
No particular.
But you would agree with me that the probable cause in the warrant, basically the latest date for anything that amounts to probable cause in the warrant was January 17th.
Yes, ma'am.
And this warrant, did you guys take it to the DA's office or have anybody review it outside your department before you submitted it to the judge?
No, ma'am.
In writing a warrant like that, have you ever been trained or taught with regard to the elapsed time between when the probable cause occurred and when you applied for the search warrant?
No, ma'am.
And the 10 years that you've been an officer, Officer Garza, are you, have those 10 years primarily been in patrol?
It's all been patrol.
Okay. And how long have you been with Van as opposed to another agency?
I went to Van in February of 2022.
February of 2022?
Yeah, it's only been a little over a year
Okay.
since I've been there.
And before that, you were with Edgewood, is that right?
Yes, ma'am.
Fair to say that Edgewood's a pretty small department.
Very small.
Okay. You worked nights there as well, is that right?
Yes, ma'am.
And a lot of times you were by yourself and didn't have much command staff above you during your shift, is that correct?
Correct.
Officer Garza, for the record's purposes, Mr. Horton, the defendant here, is a black man, is that right?
Yes, ma'am.
Is there anything that you did in this case that you did any differently because the defendant was African American?
No, ma'am, I did it. Everybody's the same.
I'll pass the registration.
Objection. Excuse. I would ask you to pay to be all of it. But I think just agree on me, I have response. Thank you, Officer Berger. You can step down, but you're not ready to go. Yes, sir. Biggs. Yeah, Biggs wanted to. Davis. Chief Davis. Raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
See? Speak up loudly and clearly, make sure we talk one at a time. The attorneys ask a question, let them finish. The witness is answering a question, let them finish before you ask the next one. If you're in any emergency vehicles, anything loud, let that sound pass. Before we continue. Okay?
Yes, sir.
Chief Davis, could you state your name, please?
Chief Melissa Davis.
And your currently
I am the police chief for the city of Van.
been a police officer.
I've been a police officer since October or November of 2008.
Tell us quickly, kind of, since 2008, we're all in
Van.
Van all the time.
Yes, ma'am. Yes, sir.
Police department.
I started out as a civilian in the Van Police Department. I was their code enforcement and animal control officer until 2009. I became the Van City Marshal in 2009. I was that for 5 years until 6 years until 2015, when I re-entered the Van Police Department as a sergeant, and then I became the Van Police Chief after that.
What year did you become the chief?
2021.
How many officers do you have working for you at Van?
Currently,
Yes, ma'am.
7.
I want to ask you a little bit about, your procedure at the Van Police Department. Things like reports and search warrants, are those required to be approved by you or somebody else?
Yes, sir.
So do you review every search warrant?
This one I had not, because when this search warrant was ready and I was in McKinney, Texas, attending the the police chief school, basically.
I appreciate your eagerness to answer my question. The court report has to take down everything we say, so we can't talk over each other.
Okay.
It's gonna be obvious to you with most of my questions, what I'm asking.
Mm-hmm.
I just asked, please let me finish my question and then respond, okay? So you didn't review this search warrant? correct?
No, sir.
What about when police reports are submitted to the DA's office as part of a case file? Do you review those reports and approve them prior to them being submitted to the district attorney's office?
Normally,
Did you do that in this case?
I did.
What about the evidence as far as digital evidence, photographs and body camera footage?
I'm sorry. All of the body camera footage should have been with the case.
Tell me how, I don't know what system you guys use, so tell me how body cam is captured, how is it retrieved and stored and ultimately submitted to the DA's office?
We use the watch guard system as far as our body camera and in-car video. And as soon as it goes back to the city, when they pull up in the car, it downloads to the server and then it goes into the cloud. And then we are able to put it on disk or flash drive to provide to the district attorney's office.
Approach your honor.
Yes, sir.
Just gonna bring my binder here. Exhibits, but I just want you to look. And if you see something that doesn't look right to you, or you think that's not correct, you let me know. So we'll start here with number 9, which is Carlson's report.
Yes, sir.
Is there somewhere on the reporting of the Van Police Department that would indicate to you whether or not body camera actually exists? Is there somewhere on there?
Well, yes, it's there.
Will that tell me if I'm reviewing this, whether or not that video actually exists?
I don't understand the question.
So my question is this, you said that you review all the reports prior to them being submitted to the district attorney's office, correct?
The reports, yes.
So this is a report, correct?
Yes, sir.
So if you see that this is marked yes for Carlson's body camera footage.
Yes,
If it's not contained in the case file, would you notice that and rectify it?
I would. Is Carlson's missing?
It actually is, but that's
Okay.
not really the point of my question. I'm just trying to make sure, trying to figure out where the breakdown of communication was.
Well, sir, I mean, I can explain. I can't explain why that was missing. I'm sorry.
But you would agree with me that if the officer indicates that there's body camera here, then that body camera should actually exist.
Yes, sir, it should.
And the same thing for Mr. Officer Hutchins, even though I think he technically works for a different agency.
No, sir, he's a part-time officer with the Van Police Department.
Now, and you obviously heard Officer Garcia testimony, correct?
Yes, sir.
Heard all the points myself, even Ms. Curry made in terms of the issues with this warrant.
Yes, sir.
Recognize that that warrant didn't establish probable cause for drugs.
Yes, sir.
Do you agree with that?
Yes, sir.
Establish probable cause for possession of a firearm by a felon.
No, sir, it doesn't.
Establish probable cause, frankly, for possession of body armor by a felon. Would you agree with that?
I would argue that a little bit, but
You would agree that it was a search warrant for his home, correct?
that's correct.
And there's a heightened sense of privacy.
Yes, sir.
Are you testifying today that you think that if you see a man wearing a vest, that you think is body armor, that would give you probable cause 2 months from now, kicking his door and running a search warrant that you testify?
No,
So you would agree with me then that did not establish probable cause to search his home 2 months after you observed. what you
the time limit, yes, sir, the time limit was wrong.
And you would also agree with me that, without seeing the inserts, you can't conclude one way or the other whether or not that vest was intended to stop gunfire, can you?
Other than Mr. Dominic Horting telling us that he had the body armor.
How many years law enforcement does he have? How many tours?
Based upon what he was told, what he told us.
You know,
No, sir.
so you're telling me that based on who you say is a convicted felon, telling you that he bought body armor off eBay, that gives you probable cause 2 months later to kick his door and search his house?
Not the search warrant, no.
Doesn't even give you probable cause to believe the crime has been committed, because you can't conclude whether or not that vest was meant to stop gunfire without pulling out those inserts, correct?
Repeat the question?
Can't conclude if it's a body armor that's meant to stop gunfire without pulling out the inserts from the vest.
That would be correct.
You know the difference between a flak vest and a ballistic bulletproof vest, don't you?
Yes, sir.
Of course you do. And the inserts is what makes the difference in those two types of vests.
Yes, sir.
Whether or not plate is meant to stop a bullet.
That's correct.
The only way to know if that's the case is to pull it out of the vest, the carrier, the Molly Luke carrier. This is what you saw.
Yes, sir.
And observe the ceramic plate that's meant to stop all. I mean, there's lots of them. You know this, right?
Yes, sir.
The kind that you guys are wearing, today, these will stop between what, a 9mm, 5, maybe 38.
Yes, sir.
Certainly not gonna stop at 22, is it?
Yes, sir.
But there's a big difference between that and what our military members wear overseas, which is the thick ones that stop high-powered rifles, like your 5.56 and your 7.62s, right?
Yes, sir.
So you understand the difference between the inserts in these vests.
Yes,
You
sir.
also understand that in order to determine whether or not the insert is designed to stop gunfire, you can't look at the vest itself and conclude it.
No, sir.
So how then, looking at simply the carrier and noticing that it has a Molly loop on it, how can you then say with any level of certainty, even probable cause, that a crime has been committed, much less keep the door 2 months later?
I can't. No, sir.
Thank you, Chief. Judge Alves. Correct.
Thank you, Your Honor. But on January 17th, Chief Davis, Mr. Horton told you he was wearing body armor. Is that correct?
That's correct.
And that is reflected in the warrant that established or attempted to establish probable cause here.
Yes, ma'am.
Chief, how often would you say in the last, well, since you became chief, how often would you say that your department has dealt with Mr. Horton in any respect?
It's been several times, but I could not give a set number.
It did, and is it fair to say that none of those resulted in his arrest other than this incident?
That's correct.
So until this day, January 17th, you didn't have any reason, or your officers, to the best of your knowledge, didn't have any reason to believe that Mr. Horton had committed a crime, a new crime, something not reflected on his criminal history.
That's correct.
So I want to walk through, because there's a lot of references to it in some of these reports and offense reports. I want to walk through kind of a timeline here, okay? Mr. Horton came into the police department on January 17th to file a complaint. Is that correct?
No, ma'am. He filed the complaint the day before.
Okay. And what was his purpose in coming in on the 17th, to the best of your knowledge?
To see if anything has been done about the complaint.
And at some point, was something done about that complaint?
The complaint that he made, that arrest warrant for that person was obtained on January the 17th.
And that was for an offensive terroristic threat. Is that correct?
Yes, ma'am.
And in that offense, Mr. Horton was the victim.
Yes, ma'am.
So you all followed up on the complaint that he had made and ultimately got arrest warrant for the person that he alleged committed a terroristic threat against.
Yes, ma'am.
And when was that warrant executed?
It was executed on March 14th, 2023.
The warrant for?
The terroristic threat warrant.
Now, I asked Officer Garza, but I'm going to ask you the same thing. Was there any particular incident that prompted you or anyone in your department, to the best of your knowledge, to go back and say, this happened on January 17th, but now it's March 20th, we're going to get a warrant, a search warrant and an arrest warrant now?
The arrest warrant was obtained prior to the search warrant.
Okay.
I couldn't tell off the top of my head, but the arrest warrant was obtained prior to the search warrant.
The arrest warrant for Mr. Horton?
Yes, ma'am. Now, the reason that both of those warrants were executed in March is because the sheriff's office was not taking those type of charges at that time. And it was not until the meeting with the chief's meeting in the sheriff's office in February that was lifted.
I have just a moment, Your Honor.
Yes, sir.
February 26th. All right, thank you, Your Honor. I'm getting a copy of that arrest warrant now, Chief Davis. We'll look at that in just a minute. So the arrest warrant had already been obtained,
Yes, ma'am.
but had not been executed. Is that correct?
That's correct.
You did not get a search warrant at the same time as the arrest warrant.
That's correct.
And why is that?
Because the arrest warrant was not executed because we could not carry Mr. Horton to jail because the Van Zandt County Sheriff's Office was not accepting those level of charges at that time
And search
for the
warrants-
terroristic threat or this charge.
And search warrants have time. Is that correct?
That's correct. And I did not realize about the time.
But I mean,
It was an oversight, but I did not read that search warrant. We should not have gotten the search warrant.
but search warrants have time limits to execute them. Is that correct?
Yes, ma'am.
So if you had gotten a search warrant at the same time you got the arrest warrant, the search warrant would have expired and you wouldn't have been able to execute it. Is that correct?
That's correct.
Your Honor, may I approach? I'll show you what a warrant is. State warrant. And I'll ask you if you recognize that.
Yes, I do.
Okay. And does that, what does that appear to you to be? What does that appear to be?
This is an arrest warrant and arrest warrant affidavit.
And who's it for?
It is for Dominic Horton for unlawful possession of metal or body armor by a felon.
And what day does it show that that warrant was signed by a judge?
It was signed on February the 26th.
And it was signed by a justice of the peace. Is that correct?
That's correct, precinct 1.
So what transpired that caused after the incident where Mr. Horton is seen in what you believe to be a vest on January 17th, arrest warrant is obtained on February 26th. Then what transpired on March 20th between those dates to cause your agency to get a search warrant for his house?
Oh, from the time that these arrest warrant, I can't answer that. I was not there when they decided to get the search warrant. I was in McKinney.
At that time, was the jail accepting this type of offense, nonviolent third degree
And
offense?
February 26th, I believe that that's when they were going to start taking them because I can't remember the exact date of our meeting with the sheriff's office where they were advised by your office that they could not accept charges.
And was that arrest warrant executed at the same time as the search warrant in March?
Yes.
Then I want to go kind of step by step through the timeline after that. After the arrest warrant and search warrants were executed on March the 20th, did something happen that caused concern within your agency about the warrants that had been obtained and the probable cause for those warrants?
Yes, I
Tell us about
believe,
Go ahead and tell us about that.
I believe that the day that they executed the arrest warrant and search warrant was on a Tuesday. Don't quote me on that, but I believe it was because shift change was on Wednesday and Officer Garza had asked Officer Mosley if she would send the return back to the judge for the search warrant. And when she saw all of the paperwork, she looked at the criminal history, and from the first charge on the criminal history of Mr. Horton, she believed that we had made a mistake and he was not a felon. So I was contacted by, at that time, Sergeant Bowles, who is no longer with our office, and stating that he thought that we may have possibly made a mistake and Gregory Horton was not a felon. So to err on the side of caution, I called you and we had him released from jail.
So now you mentioned Officer Mosley. Is that Cassie Mosley?
That's correct.
And had she recently come back to or come to work at your department?
That's correct.
And is it fair to say that Officer Mosley has been a detective, has been a sergeant, has done more in law enforcement than just be a patrol officer?
That's correct.
Would it be fair to say that she has more experience in writing warrants than some of the patrol officers in your department?
In my opinion, yes.
And when she passed that information on to you, at the same time, did Officer Bowles contact Hillary Heisel, an assistant DA in my office?
That's correct.
And were you made aware that Ms. Heisel checked the conviction and said, no, it was deferred adjudication, it was not a conviction?
That's correct.
And as you said, I believe you and I talked and we did the paperwork to let Mr. Horton out of jail.
That's correct. Mm-hmm.
Later, did you learn from me that I had reviewed in detail a full criminal history, not just the judgment from that one
Charge.
charge?
Yes.
I had reviewed the full criminal history and I believed it was possible that in fact he was a convicted felon.
That's correct.
And going back, in one of the encounters that you and your department had with Mr. Horton, he admitted to you that he was a convicted felon. Is that
The
correct?
same day that he had the body armor on in our lobby.
So he admitted that he was a convicted felon that day.
That's correct.
And when you and I talked about my review of the full criminal history, did I tell you that I wanted to wait and get the actual judgment because it's a rather obscure section of the penal code that he had been possibly convicted under?
That's correct.
Then later, did I advise you that I was preparing the case for grand jury because in fact I got that judgment and he was a convicted felon?
That's correct.
And that's what resulted in this charge being done. Is that your understanding?
That's my understanding. Yes, ma'am.
Steve, you've admitted today that prosecution. But anything that you or any member of the department did in this case, was any of it motivated by the fact that Mr. Horton is out?
No.
Was any of it motivated by the fact that the department has contact with Mr. Horton frequently on minor things?
No.
I'll pass this.
The objection to Ms. Davis, Chief Davis being excused or retained subject to discovery. Yes. All right, they can shoot him, she sat down, but.
Yes, sir.
Set up an announcement to the council. This we're gonna work until about 12:30. We'll take our lunch break. We're gonna resume at 1:30. Anything that doesn't get completed this morning, we'll look for the act. Whatever motions. Mr. Baker, right where you're at, you're fine. Of course, gonna reset your case on August 24th, all right? State that not get notice of Travis, so once you sign notice of appearance, you're free to go. Why? All right, Mr. Biggs, any other witnesses or evidence? We arrest Ms. Curry, witnesses or evidence?
No.
All right, Mr. Biggs, you for John Morgan.
Your Honor, with respect to the motion to suppress. Meeting and reveal dead horse, I would point out that the search warrant affidavit is clearly lacking for several reasons. Probably the most obvious is the stale, just talking 2 months later. And, you know, the interesting thing is that, in looking at the four corners of the document is the information related to this. For example, there's testimony, you know, about his felony conviction per 1244. All that's really beside the point because it's not contained in the parts of this document. Without that very element, they can't establish the crime was committed, or they can't establish that there was evidence of the crime located in his house. Much less the information contained in this document that ever suggests that this on March 21st, 20th of 2023, that the evidence was located in the place that they requested to be searched. So just multiple facets, issues related to all clause, the time frame, no articulation of his prior felony conviction, articulating crime of the warrant, no real articulation of all cause that a crime had been committed, period, except for the blanket observations of officers that say wearing a bullet vest. And then, of course, there's no facts that establish probable cause that these items, if you want to argue that these could have potentially been items of evidence of a crime, there's nothing in the affidavit that articulates that item is actually located at the residence that they're requesting to be searched. The last time that anyone had laid eyes on this alleged body armor was January 17th, 2023. And as the court's aware, the evidence that's been submitted is the search warrant on March 20th, 2023. I think that in terms of search warrants, I can't imagine that anybody is at this point thinking that this warrant established actual probable cause to certain individuals. Most of the statements in there are conclusory, the information is stale and not specific and articulable enough to pass that. So that reason, it has to grant the defendant's motion to suppress any evidence obtained or seized as a result of this warrant on March 20th.
Thank you, Mr. Biggs. It's great.
Thank you, Your Honor. Your Honor, the law is well settled that a search warrant, this type of search warrant, searching for evidence, has to contain probable cause that an offense has been committed and probable cause that the items searched for will be found or are likely to be found at that particular location. I disagree with Mr. Biggs on whether or not this established probable cause that an offense has been committed in one perspective. I think that the observations of the officer that an item is consistent with these multi-line, multi-carrier, multi-attachments, that an item is consistent with a bulletproof vest, and the person wearing the vest says, yes, I want a bulletproof vest, I got it for this purpose. I believe that that rises to the level of probable cause without regard to whether it rises to the level beyond reasonable doubt later at trial. The search warrant does make mention of the fact that Mr. Wharton is a convicted felon. I will concede that that is a conclusory statement that is not supported by facts in that way. The bigger problem that I see here, Your Honor, is that The second requirement of search warrants have to establish probable cause that the evidence will be is likely to be found at that location. I agree with what Mr. Biggs has said and what we got through Officer Rogers' testimony that there is nothing in the warrant affidavit to support a search for marijuana or drug. With regard to whether the search warrant affidavit established probable cause that look for the best, or the best, of all the best, the scene by the officer was likely to afterwards. It's 2 months later. Your Honor, will leave that issue with the court to determine whether that is particularly sufficiently in the warrant affidavit. I believe one other thing is abundantly clear that this is here. That is the officers acting for the faith. They believe he was a convicted felon, told them he was a convicted felon. They were relying on the wrong conviction, but in fact, he is a convicted felon. And I believe there's no evidence that officers acted any type of bad faith or ill motivation.
Thank you, Ms. Curry. Your response, Mr. Biggs. Okay. What about your discovery motion? Have those issues been resolved, or is there an issue before it needs to go on?
I believe that we've agreed that I filed a discovery motion, which granted, and she's looked at her system and realized there are some problems. So later, if we need to, I suspect, based on the testimony today, that discovery.
Is there anything in your discovery motion that's not already covered in the court's standing pretrial cases?
The only thing that would be covered, Judge, is he has asked, and I do believe it's false. He has asked for the evidence in the original terrorist threat case where Mrs. Williams were making that, but that's the only thing I saw to be outside the question. So
Anything else, Mr. Biggs, that you're seeing outside of the court's
No reason, no, Your Honor, and just so the court's aware, I'm familiar with standing order to file this motion. This needs to be testimony, because they needed to know how this evidence was been part of this stuff.
So you're not asking for the court to rule on your discovery motion at this time? You want me to wait, hear from the parties?
I don't think there's any reason not to grant it, Judge. So we'd ask you to wait and grant it.
That you're asking? Okay. All right, then the court will grant it, based on the agreement, the court will grant the defendant's motion for discovery of evidence. And then the court will take the motion to suppress under advisement and issue a written ruling on that, and provide that to counsel via email. All right, anything further in this case? All right, let's set Mr. For the docket call. Biggs, are you available on August 22nd?
Yes, sure.
Okay, we'll set Mr. Gordon in August 22nd at 9 a.m. Craig, I'm sorry to interrupt, but I need to deal with Mr. Sarate. He's still on the morning docket, Mr. Jaime Sarate, pro se.
It would be excused, Your Honor.
Yes, yes. Good to see you. Mr. Zarate, on please. This is file number CR 20-278, motion to the vote, Mr. Jaime Zarate Junior. Court will, go right over there by the table. Court will, have the record reflect that Mr. Zarate, has requested to proceed pro se. The court previously interviewed Mr. Zarate, granted their request. I just wanted an update on if there's any kind of resolution in this motion for vote.
Yes, Your Honor, he does have many. Most of it is based on community service. Mr. I visited with Mr. Durante last time he was here, told him the importance of this, the importance of avoiding assault and violence conviction. In that interim period, he has completed all of his community service now. Tells it, he sets the fire. Before August 10th, he tells us that we need their all money paid by then. And though the court has not been set in August 8th. We would have to come back then. And hopefully that's paid all that by then.
Mr. Zarate, what do you think?
I appreciate it.
Do you believe that you'll be able to have all your financial obligations paid by August 8th?
Yes, Your Honor. I mean, I didn't want to ask for loans from family members, but. I will.
Okay, all right, the court's going to reset this case for another hearing on the motion to vote on August 8th. That'll be at 9 AM. Mr. Zarate, I'm just gonna sign here and. Good copy. Good. All right, court's going to stand in recess till 1:30, once you have to adopt it.